When we talk about government agencies, one of the issues that comes up is what power does the agency have to get information about you, whether through usual channels of a search warrant and so forth, or just a regular administrative subpoena. And that's the issue that came up in Carpenter versus United States. This is a U.S. Supreme Court case from 2018 that I'm going to be talking about here. I'm Dru Stevenson. This is for my administrative law class. Let's dive in. So let's begin by talking about the standards for judicial review for agency subpoenas. And this can apply either when an agency is asking a court to enforce a subpoena against someone who's refusing to comply with it or is ignoring it, or the party that's the target of the subpoena has come into court asking the court, challenging it, contesting it, saying it's not a legitimate subpoena and that they shouldn't have to comply with it. And we have four main issues, and the first two are the ones that come up the most often or are the most kind of important in practice. So the first is whether the agency has statutory authority to issue subpoenas. So there needs to be something in the agency's enabling statute or a relevant statute that says that this agency has subpoena powers. Usually that's the case, but it's always worth checking because if they don't have statutory authority to issue subpoenas, then they probably can't issue subpoenas. The second is the germaneness of the information sought to a lawful inquiry for that agency. For example, it makes sense why the Internal Revenue Service would want bank records and receipts of purchases and sales and so forth. It's less clear, say, why the Highway Department or Department of Transportation needs your bank records or your receipts from your last vacation and so on. And so it needs to be fit within something that the agency is supposed to be doing under their statutory mandate. The third is the reasonableness of the scope. The agency can't ask for every text message that you've ever sent or received in your whole life, or every email that you've ever received at any email account in your whole life. That is kind of ridiculous, and there's no way that the vast majority of that is relevant to an agency's investigation. So it needs to have some reasonableness to the scope. And the fourth is going to be just a technical legal analysis of the subpoena's form, of the document itself, that it's properly drafted and executed, and so forth. A couple other points about subpoenas and agencies. The Supreme Court has historically been pretty lenient with deferring to agencies about what the agency thinks is their own jurisdiction about subpoenas. And so it's not a presumption against the agency or anything close to that. Also, keep in mind, and this can really matter in practice, that an agency may be using a civil administrative subpoena and it can in order to obtain information that will later be useful for a criminal prosecution. And the Supreme Court has said that that's okay. It doesn't matter if the agency has an ulterior motive, that they're hoping that they're going to get information that will allow the person to be sent to jail. If the administrative subpoena itself is valid, it doesn't matter if the information will then be used in a criminal case as well. And so if it's reasonably related to the agency's civil enforcement duties and responsibilities and powers, then the subpoena is likely to be valid. Also keep in mind that Congress has explicitly authorized administrative subpoenas for criminal investigations. And one example would be under the HIPAA statute. It grants the Attorney General the power to issue subpoenas for the FBI to use in federal healthcare fraud investigations. And that's just one of many, many examples we could give. Over time, these congressional authorizations have added up, and it's created a significant expansion of the investigative subpoena power that's really just being used for criminal enforcement. And these subpoenas have successfully withstood Fourth Amendment challenges in the courts over the years. Now, the Carpenter case is kind of a turning point in this area of law. There have been repeated affirmations from the courts of prior rulings, like the Oklahoma Press case from many decades ago, regarding agency subpoena power. And then we get to Carpenter versus United States in 2018, And the court sort of pivots. So this introduced a critical distinction about whether a higher standard than mere reasonableness is necessary when we're issuing a subpoena for records in which an individual has a reasonable expectation of privacy. Now, the specific question in Carpenter versus United States is whether the government has conducted a search for purposes of the Fourth Amendment when it accesses your past cell phone records or location records that provide basically a comprehensive chronicle of all of your movements over the last few months. I don't want to go into all the technical details here, but we just need to talk about this one term that runs all through this case, which is CSLI, or cell site location information. These are time-stamped records that are generated multiple times a minute whenever a cell phone is actually turned on and is connecting to nearby cell towers for service, even if the person isn't making calls. And you've probably seen this in movies or TV shows where they use the person's cell phone data to track their movements, sometimes even in the past or sometimes in the present. All this past cell phone data is actually preserved by the the wireless carriers like T-Mobile and Sprint and so forth, because it's useful for their business practices. They want to know where to target different ads, and they also want to keep track of where their own company's service is spotty or strong and things like that. So they keep these records and have really a vast archive of very precise CSLI for all of their users or subscribers. And unsurprisingly, government investigators find this information very useful in tracking the movements of their suspects or people that are under investigation. So let's talk about the facts of the Carpenter case itself. Here, there was a robbery suspect who identified his accomplices in a string of robberies, and one of those was Mr. Carpenter. So the FBI obtained some court orders under a statute called the Stored Communications Act, or SCA, to acquire Carpenter's cell phone location records for the past 4 months. And this information was used at trial to place Carpenter's cell phone near 4 of the robberies that were at issue in the case, and he was convicted. Now, over the last 50, 60, 70 years, the Supreme Court had established for search and seizure law or criminal procedure something called a third-party doctrine. And this basically said that individuals have no legitimate privacy interest in information once they've turned it over to a third party, like the phone company. And so one of the famous cases was whether the police have the right to go get a list of all the numbers that had been dialed from your phone. And the Supreme Court had said yes, because when you dial phone numbers, you know that you're giving that information to the telephone company so that they can connect you to someone else's line. And therefore, it's not reasonable. You know someone else knows which numbers you've dialed, so you don't have a reasonable expectation of privacy in that. And this also can apply to some bank records and so forth. The big surprise here was that the Supreme Court decided not to extend this third-party doctrine to CSLI, or cell service location information. It held that the unique nature of cell phone location records and the seismic shifts in digital technology differentiate this type of case from all prior precedents. In the Carpenter case, the Supreme Court said that cell phone location information is not really shared voluntarily like the phone numbers that you dialed, because it says that phones are such a pervasive and insistent part of daily life now. And furthermore, when a cell phone logs the location of the phone, just by virtue of its operation without any affirmative act by the user, again, like dialing a number, if you have your phone turned on, your phone's location is visible to the cell towers in that area, the broadcast service. And so it's really difficult to avoid leaving a trail of location data, the Supreme Court said. So, our holding in the Carpenter versus United States is that an individual maintains a reasonable expectation of privacy in the record of their physical movements that are captured through cell service location information, or CSLI. And that meant that the government's acquisition of such records constitutes a search for purposes of the Fourth Amendment. And if so, that means they're going to have to get a search warrant to get the information, which they hadn't done in this case. Just to reiterate this point about the search warrant being required, once the Supreme Court determined that CSLI is a search for Fourth Amendment purposes, then it means that the government most of the time is going to have to obtain a valid warrant that's going to be supported by probable cause, signed by a magistrate, and so forth, before they can acquire such records. Now, if you take a course in criminal procedure, you know that there's a few exceptions to the warrant requirement, like exigent circumstances and so forth. But the default rule is that the government officials or law enforcement will have to get a search warrant in order to get this information now. One of the issues that we have in this case is a little bit of tension between our longstanding jurisprudence for search warrants and this statute, the Stored Communications Act, or SCA, because that statute says that for cell phone records, the only thing that's required would be reasonable grounds to believe that records are relevant and material to an ongoing criminal investigation. But the Supreme Court said that this falls short of the constitutional requirement of probable cause that we've had for a long time for Fourth Amendment searches. And therefore, the statute's mechanism here is impermissible under the Fourth Amendment for accessing historical cell site records. We had several dissenting opinions from the conservative justices in this case, especially a really long one from Justice Alito. And they argued in different ways that the majority should have followed their prior precedents about phone information, not needing a warrant, and arguing that producing such information is not really a search. For purposes of my course, I don't want you to dwell on the dissenting opinions in this case, but you should be aware of them. At least two of them are reprinted in our casebook, or at least excerpts from them. So let's talk about the impact of the Carpenter decision. Carpenter reclassified cell phone data, location records at least, from a third party as a traditional Fourth Amendment search that requires a warrant based on probable cause, rather than something that you should be able to get with just an administrative subpoena. And the reason for this was what the court saw as an individual's reasonable expectation of privacy, or their legitimate privacy interests in having their movements tracked and then made disclosed to law enforcement. This decision does raise questions about whether other kinds of third-party records where individuals may have sufficient privacy interests will also be treated as searches rather than subject to subpoena going forward. Before we wrap up here, just a couple other things to note about administrative subpoenas and other types of constitutional rules that can come into play here. Administrative subpoenas are not self-executing. In other words, if someone refuses to comply with it or ignores a subpoena, the agency will have to go and seek judicial enforcement of it if the person contests it. And again, this is going to create at least a two-step procedure for courts to scrutinize whether the agency has authority to issue the subpoena and the propriety of the information it's demanding before the court enforces the subpoena. A little bit of law a student should keep in mind here is that Congress can authorize criminal penalties for noncompliance with agency administrative subpoenas. So even if the agency is not bringing a criminal case itself or prosecuting you, Yet, if they have a legitimate administrative subpoena and Congress has provided this type of sanction, you could be charged with a crime for just for refusing to comply with the subpoena or produce the information. Agencies usually avoid this route because, again, maybe it would attract increased judicial scrutiny that we would normally have applying to criminal procedure and search warrant requirements. In the casebook I use for my course, in the notes after Carpenter versus United States, the casebook authors mention the issues about the Fifth Amendment, and you're probably familiar with people taking the Fifth or invoking the Fifth Amendment right against self-incrimination, that they don't have to answer questions and so forth. Though the Fifth Amendment can apply in administrative proceedings, and usually for, again, documentary materials, whether you have to turn over a certain or produce documents, but it's significantly limited. And I just want to explain a little bit of the reason why, so that when you go into practice, you understand the Amendment is usually not a very robust tool for resisting agency subpoenas. The first is that the Fifth Amendment only applies if the disclosure could lead to, of the information, or answering a question, producing a document, could lead to a criminal prosecution. You can't invoke the Fifth just because something would ruin your reputation or hurt your personal relationships or business relationships, uh, um, or even subject you to administrative penalties like having a license or permit revoked or being barred from government contracts or something like that. So if it's a civil penalty that you're worried about, or some sort of social penalty like ruining your reputation or being going down in disgrace because of the information that you want to keep private, the Fifth Amendment isn't for that. It's only to protect against criminal investigations. Also, when we're talking about the Fifth Amendment privilege against self-incrimination, keep in mind that it's usually not available to corporations as an entity or to the custodians of the corporate records. They can't say, I'm not going to produce this because it would subject my corporation to an enforcement action or something like that. The Fifth Amendment privilege that courts have held, at least up till now, applies to real human beings and not to corporations, even though for some other legal questions, we treat corporations as a legal person. Also, you can't invoke this on behalf of someone else. So you can't say, I don't want to answer that question, or I don't want to turn over those documents because it will incriminate my boss or it will incriminate my coworker. That's not a valid application of the Fifth Amendment. The court will say you have to produce the information anyways. And that concludes our discussion of Carpenter versus United States, a 2018 U.S. Supreme Court case. Thank you for watching.